In studio is Christopher Pelli. Chris was the attorney during the Conley trial. Would you call? I mean, obviously, you wanted a plea, or you wanted a verdict of not guilty.
Obviously,
but I would say that that a hung jury was the next best thing. Would you agree?
There's no doubt that
Yeah.
it's the next best thing, and I would go so far as to call it a victory.
Yeah. I have to tell you, I thought you did a brilliant job at your goal here is to create doubt in the minds of the jurors. I thought you did a really good job.
Thank you. I thought I did too. I thought I was so effective that we would have a verdict in 15 minutes instead of 5 days, quite frankly.
So tell me your thoughts. I mean, she has chosen to use a different attorney going forward. Was that your choice to not go forward, or tell me what happened?
Well, you know, Bill, honestly, the right of the defendant to choose their own attorney is so basic and personal that I don't feel competent to talk to you about it.
Okay.
I really don't. I mean, it's a decision that the defendant makes. I support her 100%. I continue to support the whole family and Mr. Policelli, and I pray that there's a good outcome.
Now, attorneys, when you go, I always talk about how I was once in family court, and the opposing attorney was just saying questions, leading questions that were so terrible about me that weren't true. Mm-hmm. And when I went out into the hallway, there's my attorney and her attorney, and they're smiling and they're talking like nothing ever happened. I'm like, how could you do this? This guy's the enemy. The reality is, though, you don't get personally involved. That's how you try. Did you get at all personally involved here? And in a way that, do you feel that she's not guilty? Do you have personal feelings, or do you go forward with blinders on?
It's very, very. I try to go forward with blinders on, but it's very, very difficult when you have a young lady and her father crying for their freedom, and you're working on the case for a year and not develop some type of opinion on the matter. Mm-hmm. I mean, I've looked at all the evidence. I've had the opportunity to speak with Kaitlyn over a long period of time. So, I feel that she's absolutely innocent. It's not a question of whether she's not guilty or guilty, rather, she's innocent.
Now, we had the the district attorney on, and we've heard him talk about the fact that, boy, this case was just, and others talk about this, and this was so technical that they lost the juries, the prosecution. And even as much as the DA saying, we definitely have a strong case here, and that's why we're going forward. There's no doubt in our minds that this is the person that committed the crime. How do you respond by that?
This is an evidence-based game, and feelings go only so far. So the district attorney's opinion that that this particular person is guilty is his, and it's fine to have. Yeah. But the evidence is not there to convict. There simply isn't.
When they say technical evidence, what are we talking about?
We're talking about computer forensics and very difficult to interpret circumstantial evidence. But what's being ignored are the facts. At least, well, they weren't ignored by the 8 jurors that wanted to find not guilty. But
so the number is 8.
The number is 8.
I heard it changed as they got closer. That actually changed in your favor as it got closer. Is that the case? Or was that the final?
I spoke to 2 of the jurors at length, and I was told that the count went from 8-4 to 10-2, and then minutes before the note requesting mistrial, basically, minutes after the note, the vote changed again.
They switched back.
Yeah.
Okay.
Back to 8-4.
Okay, got it. Andrew, you had a question?
Yeah, no, my question was, I'm sure all cases are stressful for an attorney, but for you, with the media attention and being that it was kind of complex in nature, where does this stack up to cases that you've had in the past?
Well,
on a stress level.
Yeah, I don't. The media doesn't stress me, but the the quality of the family that you're dealing with. They're very, very. I mean, nobody will dispute the family is just wonderful. Combined with the length of time and the different sets of expert testimony that you had to deal with. You know, we didn't just have to freshen up on DNA or freshen up on computer forensics.
Right.
We had to relearn or learn it. So for me, it was probably the most complicated case that I've ever handled.
Go ahead.
Were there things that you fought for that you didn't want admitted as evidence that you came up on the short end on, and what were they?
The biggest thing, and really one of the few, the biggest thing that comes to mind is the statement, of course. In my opinion, it was taken by violating her constitutional rights, and we argued that point early, and it was decided quite early that that didn't happen, and that the statement would come in.
Would you argue that again?
I argued that.
I mean, if you had to do it all over again, would you argue that again? That same point?
Yes.
Yeah.
Oh, yeah. Yeah, absolutely.
Okay.
We did that in front of Judge Donalty in the beginning, and Judge Donalty found that the statement was admissible, and we had to deal with it.
Yeah, yeah.
And what was the, I guess, admission, or what was the problem with the statement? I shouldn't say admission.
Yeah, there were no admissions, and the problem with the statement to me is just that it looks something other than great for the defendant.
Okay.
You know, I mean, just the fact that there is a potential negative, you know,
Right.
You know, if you show the defendant crying, half the people might say, okay, that's a sign that she's guilty. The other half might say, no, that's a sign that she's in distress. So you've got this additional job of explaining or trying to explain what's happening in this particular situation.
With regard to her statement, though, I found it curious. How significant was it that she never asked for an attorney at any point during the questioning?
Well, significant it's significant to the extent that I always tell everybody that unless you're on fire or somebody's chasing you with a gun, you don't talk to the police.
Right.
That's my advice to everybody.
Yeah. Well, you're speaking to them without someone there telling you should say this or you shouldn't say this.
Oh, of course.
And she spoke without an attorney.
She did, and she did. I think approximately 7 different times on 7 different occasions.
Wow.
Just wanting to help.
And what you say to that is that for you is proof. You believe that she did not consider herself a suspect.
Not even remotely until the end. She tried to help these people as much as she can. She provided as much information as she could. She was met with lies and ruses, which caused some real confusion, I think.
I want to ask you about a couple of things. During the trial, the husband was someone that you really pointed, I don't want to say pointed the finger at, but I guess maybe you did.
I did.
And there were a smoking gun, if you will. I thought at the end when it was revealed that the husband and the sister were actually, unlike what we were previously told, actually were seen together. You have a witness.
The only direct evidence in the entire case, and keep in mind, the defense has no duty to come up with any evidence.
Yeah.
We don't have to do that.
Right.
But the only direct evidence was from the defense, from a very disinterested witness, a neighbor of Kathy Richmond, who very clearly was able to state that this particular act that she saw happened 2 weeks prior to Mary's death, and she knew why it was 2 weeks prior, and she knew who Bill Yoder was, and she knew who Mary or Kathy was. I think it was compelling.
But Bill Yoder had said during testimony that they did not get together romantically until some weeks after the death.
Well, of course,
right,
of course.
But to me, there's your. Boy, all of a sudden you kind of wonder, why would he not tell the truth there?
It's obvious that why he wouldn't.
Right.
He has immunity with regard to the murder, but certainly not with regard to any perjury or making of any false statements.
Understood.
So he's got to stick to his guns on that one.
Talk about the granola bar. So that played a role.
The
bar. Well, it was good. And wasn't there? Didn't there come a time where it was that it was said that she wouldn't ever eat something like that, but she did on that day? What happened during all of this?
I think that there was some testimony lost in the shuffle. There were Mary. In my understanding of the evidence is that Mary very much enjoyed these protein bars.
Yeah.
They were something that she sold to customers and invariably kept in her purse and for on-the-go types of things. And ultimately, it was stated on the hospital records that patient states ate protein bar for lunch.
Yeah.
And indeed, I was able to identify through the prior secretaries and everything the exact type of protein bar that she ate, and we presented that as an exhibit. And the reason that that's so important is because I felt as though the evidence upon which the grand jury based their indictment had to do with the ingestion of a protein shake. Which I don't believe was ingested or available at that day.
Okay, and did there come a point where, based on the testimony, where she had gone to the hospital and she began to feel somewhat better? I had heard that as a rumor, and then she took a turn for the worse. And of course, the implication being the only person that had contact with her during that period would have been her husband.
Yeah, I don't know if I would use the words feeling better, but she was certainly less stressed, physically and psychologically. And it was just a couple of hours later that she had fallen and began a sharp, quick decline. And that was just a couple of hours after her last meeting with Bill, who brought to her cough drops, an inhaler, a dry powder inhaler, and so forth, against the orders of the hospital, by the way.
I hate to say, but had the Kaitlyn Conley not spoken to police, would she ever have been a suspect? Because the more we hear out of the evidence that came out of, or the testimony that came out of the trial, the more you kind of follow where you're leading us towards another potential killer in this situation. But there is the evidence that she spoke with police and she lied about it. She sent the letter. She might have lied about certain things. Had she not said those, would she have ever been a suspect?
I hate to speculate about that, but there's such little evidence in this case, in my opinion, that I think that any portion of it, whether it's her statement, not confession, her statement, or a couple of the other circumstances that were used to support if you knock any one of them out, you really have nothing.
And why the letter? Why did she say she sent the letter?
That's something that I can't answer.
Okay. All right.
At this point. I'm not her attorney. It's something that, it's a confidential type of communication. So, but there's very good reason for it. Very good reason.
All right. And I'll also ask you, so when Mr. Policelli goes forward, what does he have? Can he speak to jurors? Does he have all of the evidence that came out in the trial and then can search for more?
Indeed. I provided him with the entire file, and that sounds small, but it's several boxes
I can only imagine,
information and several hundred, about 800 gigabytes of information, thousands and thousands of pages of documents and text messages, and it's dizzying. He has everything.
Yeah.
And, of course, he can put his new set of eyes on all of this and either go with the same type of questioning and line of defense that I did, or choose something completely different.
I don't want to. It's a tough job for the jurors, and this jury sat through a lot.
They did.
So I don't want to criticize at all. However, I think that if a juror were to follow the exact instruction, and that is, if you have any reasonable doubt, which it's really, the language is interesting. You really have to look into the language and get definitions. So what does the word reasonable really mean? But at the end of the day, I feel that it should have been a not guilty. Not criticizing the jury, but I mean, you had reasonable doubt that you presented that she is absolutely not the murderer, or that she is not absolutely the murderer.
We were swimming in doubt, and you're right. The definition of what's reasonable about that doubt is very, very hard to articulate. In fact, impossible. It's not math.
Yeah.
We rely on our own words to define these words, and they mean
they might have asked too at one point, didn't they? One of their questions they came back with.
I believe they asked twice.
Yeah.
I believe.
That's a tough challenge, because you're you'd be sending someone away for the rest of their lives.
Yeah. And Bill, the bottom line is the conflict in that jury room in and of itself, if you're to believe that those are reasonable people. We picked them. Right. You know, it proves doubt.
Yeah.
You know?
Going forward, let's say the same result comes, that it's a hung jury. Will they retry? Or if she's found not guilty, what does the district attorney do then? Do they feel they might be able to try a case
she's found
against
not guilty, she's done.
Pardon?
Oh, you mean
no? I'm saying going forward, would they then have a case to charge the husband or another suspect, or would that make it so much more difficult?
No, that's one of the I think the missteps here, if I can be so bold, was to grant Bill and his son immunity. Now they're good forever.
Oh, they were granted immunity.
Indeed, they were. Yeah. So no,
for their testimony,
it creates a real need, I think, for the district attorney to make sure that this is a case that is won, and because losing it results in the public saying, "Okay, well, are you going to charge the other person now?" And they're going to have to stand up.
I didn't realize that. I didn't remember that fact. So Bill Yoder cannot be charged.
Never, ever, ever. Nor can Adam.
Wow.
For what?
Well, I know why give them the immunity.
This is a question that you will have to get from the district attorney's office. I've spoken to other DAs in other counties about this situation, because I've never really seen this before, where you grant immunity to somebody that even if you think that the person is not guilty, you protect yourself and the office by making that person come in with an attorney and giving proper testimony, so that if something like this happens, you've got your fallback.
Right. Or if testimony were to come out during the trial, as it did, it would make you say, not as maybe more potential than we thought. I mean, certainly, I want to really reiterate that Bill Yoder is not on trial, he's an innocent man, and we are not accusing him of anything. But you certainly, part of the trial, you had to point fingers, and you pointed fingers at Bill Yoder. But this to me is brand new news. I guess I missed this through all of this, that he was given immunity. So it's that is over. If she's found not guilty, this basically ends.
Goes unsolved.
Basically,
it ends.
It completely ends, and
unless there's some mystery person out there that we didn't know about.
Indeed. I couldn't tell you for sure. I'm not sitting here telling you that exactly what Bill Yoder did.
Right.
You know, I'm telling you that
needed to show
there are circumstances that, in my opinion, the circumstances that support any potential conviction for Bill are much higher with motive,
based on
than they are for Kaitlyn.
Compelling conversation here. I appreciate it. Thank you so much, Chris, for coming in.